The committee will be in order. It is now in order to consider Amendment Number 3, printed in Part A of House Report 113-378. For what purpose does the gentlewoman from Texas seek recognition?
Mr. Chairman, I have an amendment at the desk.
The clerk will designate the amendment.
Amendment Number 3, printed in Part A of House Report Number 113-378, offered by Ms. Jackson Lee of Texas.
Pursuant to House Resolution 511, the gentlewoman from Texas, Ms. Jackson Lee, and a member opposed, each will control 5 minutes. The chair now recognizes the gentlewoman from Texas.
I thank the chairman very much, and frankly, maybe I should offer a good thanks to the distinguished members of the majority, the Republicans, my chairman, and others, for giving us an opportunity to have a deliberative constitutional discussion that reinforces the sanctity of this nation and how well it is that we have lasted some 400 years operating under a constitution that clearly defines what is constitutional and what is not. The Enforcement Act is not constitutional, but it gives us an opportunity to raise these issues. That's what freedom is. That's what the opportunity of democracy is all about. So the Jackson Lee Amendment engages in this discussion to reinforce that there are constitutional problems with the Enforce Act. My amendment excludes from the scope of the bill any executive action taken to comply with judicial decisions interpreting the Constitution or federal laws. The amendment would ensure that one house of Congress could not initiate dilatory legal challenges when executive actions were taken to comply with the judicial decisions. A couple of weeks ago, I believe in the month of February, the Speaker of the House came forward and gave a light upon a serious issue when they announced that they were prepared to move forward with discussions on immigration reform. Then, less than 5 days later, the Speaker took to the airwaves and indicated that that offer of bipartisanship has been pulled down because of the trust question of the President of the United States. And Mr. Chairman, I cannot tell you what happened in those 5 days. The President led the country. The President provided for the country. The President listened to the American people. And the President has been in the commander-in-chief. The President has provided that kind of fiscal responsibility, working on the omnibus, the budget, and I don't know what happened. But what I will say to you is I can see no reason for this kind of legislation to come to the floor of the House and to be able to clearly poke a spear, if you will, in the eye of Article 2 that says the executive power shall be vested in a President of the United States of America. This President has that power. My amendment will ensure that whatever passes here allows the President to be able to handle the business of the American people through judicial and federal statutes without interference. I'd ask my colleagues to support my amendment, and I reserve my time.
Gentlewoman from Texas reserves her time. For what purpose does the gentleman from Virginia rise?
In opposition to the amendment.
The gentleman is recognized for 5 minutes.
Thank you, Mr. Chairman. I oppose this amendment as it would gut the bill. Read the text of the amendment. The amendment would explicitly prohibit the bill from affecting the executive branch's compliance with judicial decisions interpreting the Constitution or federal laws. But that's exactly the point of the base bill. The base bill encourages the courts to decide constitutional issues relating to the Constitution's separation of powers between the branches of government. We would, of course, expect the President to obey those decisions from the courts, yet this amendment would grant the President the authority to defy those very court decisions by making sure that the President did not have to be, quote, affected, end quote, by them. This amendment only adds insult to injury. It would take a bill designed to encourage the federal courts to engage in the constitutional issues of the day and amend it to explicitly allow the President to defy the decisions of those courts. There is no reason to exempt court decisions from the bill's coverage. The base bill allows Congress to bring lawsuits if the President fails to faithfully execute the laws. The President is obligated to follow federal court decisions to the same extent he must follow federal statutes, treaty obligations, and, of course, the Constitution itself. Rather than furthering the bill's goal of enforcing the Take Care Clause, the amendment would create an enormous loophole in the bill's coverage, and so I must urge my colleagues to reject this gutting amendment.
Does the gentleman reserve the balance of his time?
And I reserve the balance of my time.
Gentleman from Virginia reserves the balance of his time. The gentlewoman from Texas is recognized.
Mr. Chairman, how much time do I have?
Gentlewoman from Texas has 2.5 minutes.
Well, let me just make this point, and I'm going to yield 15 seconds to the distinguished lady from California. But I thank the gentleman from Virginia for his eloquence. Obviously, he is from the great state of Thomas Jefferson, and I certainly am from the great law school of Thomas Jefferson, the University of Virginia School of Law. But let me just say that what this bill intends to do, the power the bill purports to assign to Congress to sue the President over whether he has properly discharged his constitutional obligations to take care that the laws be faithfully executed, exceeds, he knows that exceeds any constitutional boundaries. He's challenging the President on decisions that they don't agree with that are political. They don't agree with deferred adjudication. They don't agree with the DREAM Act youngsters. They don't agree that we should move forward on immigration reform. They are challenging him on his right to exert his power. I yield 15 seconds to the gentlelady from California.
Gentlelady from California is recognized for 15 seconds.
Mr. Chairman, I agree with the amendment. I would note that the late Henry Hyde signed the letter urging for prosecutorial discretion that is part of the law recognized by the Supreme Court in the Arizona case. I do not believe that the late Henry Hyde would have urged the administration to do something that did not comport with the Constitution or the law, and I would ask unanimous consent to put this letter into the record.
The request of the gentlewoman from California will be covered by general leave. The gentlewoman from Texas is recognized.
Chairman, the time remaining.
The gentlewoman from Texas has 1.25 minutes left.
I'm going to reserve my time.
Gentlewoman reserves her time. Gentleman from Virginia.
Mr. Chairman, I believe that I have the right to close. If that is the case, that I would reserve the balance of my time.
Gentleman is correct. The gentlewoman from Texas is recognized.
I thank the chairman. I just want to ask the chairman, there are no other speakers, Mr. Chairman, but yourself. Thank you. As I indicated, this is a political fight. And I thought that we had settled that fight with Baker v. Carr, a case that hails from 1962. Baker stands for the proposition that courts are not equipped to adjudicate political questions and that it is impossible to decide such questions. Now, our friends want to give Congress the right to expedite their lawsuit over the average citizen on a political question, first in a 3-judge court, and then right to the Supreme Court of the United States, while the American people suffer because they want that particular position. It's a political question because it's the Republicans who want to be able to move beyond the authority given to the Constitution. I'd like to yield the gentleman 15 seconds.
Thank you very much, because this is an important amendment, and it doesn't gut the bill, and it isn't a loophole. This is a narrow amendment that only ensures that the President can comply with court decisions. Separation of powers principle is very important, and this amendment clarifies and adds to it. I thank the gentleman.
Time of the gentleman has expired.
I thank you very much to the gentleman for that very astute analysis, and I want to conclude, if I might, by saying that I respect the separation of powers. And I understand what my colleagues, Mr. Conyers is very right. This amendment does not gut the legislation, but I understand what my colleagues are saying. And what I would argue is we all want the same thing, that the authority of the President remains that, the Congress, the judiciary, and there's no exceeding. I believe we can do it in a better way. I ask my colleagues to support the Jackson Lee amendment.
Time of the gentlewoman from Texas has expired. The question is now on the amendment. I'm sorry. The gentleman from Virginia is recognized to close.
Thank you, Mr. Chairman. That's all right. I will be brief and just say that for the reasons already cited, this is a very harmful amendment. It would gut the bill. For that reason, I oppose it, urge my colleagues to oppose it, and yield back the balance of my time.
All time has been yielded back. The question is on the amendment offered by the gentlewoman from Texas. Those in favor will say aye.